Well, good morning, ladies and gentlemen, and it's wonderful to see so many familiar faces, fresh from the summer, here in the courtroom. This is our first attempt, I suppose, at a mostly web-based seminar. There are about 90 people online, sitting in their offices or at home, watching us as well, and welcome to all of you there. And it's our intention over time to provide this web-based technology for lawyers and people interested in the lectures who can't actually physically come to the DIFC to see it. So welcome to you all. For those who are yet to purchase tickets for the gala dinner, your names will be taken after this lecture, and serious sanction will continue unless you purchase a minimum of 5 tables, and that's for everybody online as well. You can purchase the tickets from the DIFC Court's website. For those in the room, you can get them from Haja, who's standing just over here. I think we're over the 450 mark, still some way to go to reach our goal of close to 800. And welcome to this seminar on our new Code of Professional Conduct, or revised Code of Professional Conduct. I would like to introduce the Chief Justice of the DIFC Courts, who is directly behind me, a judge, a Chief Justice not just of our court, but of the Dubai World Tribunal, where he sits as a judge, former President of the Law Society of Singapore, former non-resident ambassador for Singapore in Switzerland, recognized by Who's Who's Legal as one of the world's leading dispute resolution lawyers, and most recently awarded an honorary doctorate of laws by the University of Sydney in May earlier this year. So I'm delighted to hand over to Chief Justice Michael Huang to take us forward on this seminar. Thank you.
Good morning, everyone. Let me just start with a quick recap of where we are. When this court was established, my predecessor promulgated a mandatory code of conduct for registered practitioners in the DIFC courts. That remains until today the binding code for professional conduct of advocates before this court. Recently, we enacted the DIFC Court's Code of Best Legal Professional Practice. That was meant to be a comprehensive, non-binding code for the legal profession in the DIFC. And it had basically 2 components. A component which covered transactional lawyers and a component which covered dispute lawyers. And we announced at that time that while the whole Code of Best Legal Professional Practice was meant to be non-binding and a guide essentially to best practices, we would in due course be migrating those provisions from the code into the mandatory code. And that is the exercise that has been occupying us since. So once we adopt the new mandatory code of conduct for practitioners in the DIFC courts, that will replace the existing mandatory code, and we will then reissue the Code of Best Legal Professional Practice in a reduced form, taking out all of those provisions which have been migrated, so that essentially it will be applying to the general duties of lawyers who carry on practice, mainly in transactional matters, but also to some extent, some of these rules in the code still would have application to lawyers in disputes practice. And so they will also be expected to comply with that, even though on a non-binding basis. Let me now take you to the new mandatory code. What has happened here is that when we were putting together the new mandatory code and assembling the provisions from the non-binding code for migration, we made a long list of those provisions which were applicable for court practitioners. But we didn't want to confuse people too much by just replacing the old list completely with a new list. So we've tried to make the new mandatory code look like the old one. Now I'm going to take you through where there are substantive additions to the old code. But to assist people in understanding what the obligations under the mandatory code are, we are issuing at the same time a practice direction which is called the Supplementary Code of Conduct Practice Directions. When you look at the two documents that we will have, one will be called the Mandatory Code of Conduct for Legal Practitioners in the DIFC courts, which is the one that will replace the existing mandatory code. And then you will see another document entitled Supplementary Code of Conduct Practice Direction Number 1. Notwithstanding it's called a supplementary code and it's a practice direction, it is to be read together with the mandatory code and therefore is also mandatory in its effect. Let me first go through what the new provisions are in the mandatory code, after which I will turn over to Philip Punwa for an explanation of the supplementary code. We now divide the mandatory code of conduct into various parts. Part A will be the governing principles. And we've added in new provisions here, which will be elaborated on later on in the mandatory code. But in the governing principles, we've added two new principles. The first, the recognition of the court's power to refuse to permit a specific practitioner to represent a party or continue to represent a party where, in the opinion of a court hearing the matter, the integrity of the process would be threatened by that practitioner's representation of the party or the fair administration of justice in accordance with the overriding objective at Part 1.5 of the RDC would be put in peril. This particular provision gives the court an overriding right or discretion to say that in the circumstances of a particular case, one particular lawyer, and possibly even that lawyer's firm, should not act. And essentially that will apply in cases of conflict of interest. There actually is a precedent for this from Singapore, where in one case, just as the trial was starting, one party stood up and said, I want the court to disqualify the firm representing the other party because my clients formally had consulted them on the same matter. The court's judgment was very interesting. He says there are two ways we can deal with this. The first way is I simply disqualify this particular lawyer, but because of the way that the Singapore professional conduct rules were drafted, he felt that the entire firm was, if you like, impeached or contaminated by the conflict, and therefore he disqualified the whole firm. Now, you may ask whether or not that is within the legitimate province of a court to deal with a matter which is essentially a breach of a professional rule of conduct, and just leave it to the Bar Council or Bar Association to deal with that. And the judge in that case made the interesting observation. He says, yes, if it was a simple breach of an ethical rule, I would leave it to the professional body to deal with it. But where you have an entire firm which is conflicted, it would impair the integrity of the process. There would be a question about the legitimacy of this process. Therefore, I feel that I have the right to disqualify that firm. So if you accept that as a valid basis for interference by the court, then this particular principle seeks to memorialize that particular concept, which I would say is in fact ingrained in any event into the whole judicial process, whether you come from a common law jurisdiction or a civil law jurisdiction. And the reason why I say that is that we are grappling with this problem in international arbitration right now, as to the extent to which a tribunal is allowed to disqualify or even sanction counsel in the course of a proceeding. But everyone agrees that if the integrity of the process is going to be threatened by any behavior on behalf of, by any counsel, the court has an overriding power to take charge and remedy that element of imperilment where necessary. The second new principle that we are bringing in under general governing principles is the recognition of the court's power to suspend, terminate, or place conditions on a practitioner's registration in circumstances described in Part G. And I'll come to Part G in a moment. The next section that I want to deal with is the duties owed to the court. You will find this in more or less familiar form. It reproduces the provisions from the old code. In Part B, Rule 3, we have tweaked this slightly. What the existing code says is that practitioners shall ensure that they are familiar with such laws of the DIFC as may be applicable to the matter before the court. The new Rule 3 says practitioners shall ensure that they are familiar with such DIFC laws and Dubai laws establishing the DIFC as may be relevant to the matter before the court. This is really meant as only as guidance to point out to practitioners that when they are arguing jurisdictional issues, they need to refer not only to the DIFC laws, but to the Dubai laws which established the DIFC and this court. Under the same section, Part B, duties owed to the court, I'm going to take you now to a new rule, which is completely new. It's Rule 6 of Part B. Practitioners shall not appear as advocate or otherwise conduct proceedings before the court in any matter in which they have reason to believe they may be a witness, save where any evidence they may give is likely to be purely formal or uncontroversial. I think those of you, at least from common law jurisdictions, will be familiar with this particular rule. It appears in some guise or other in most of the professional codes of conduct, and I think there will not be a lot of dispute about the relevance or applicability of this principle in the DIFC courts. I'm now going to run through the next section very quickly, Part C, duties owed to clients. I only draw your attention to one new rule. Some of the wording has been tweaked a little bit, but those changes are not essential to an understanding of their meaning. But we have introduced a new conflict of interest rule. Under Part C, Rule 15, practitioners that have acted for a client in a matter shall not thereafter act against the client or against persons who were involved in or associated with the client in that matter, in the same or any related matter before the court. So basically what it says is that if you have acted for a client in a particular matter, you can't act against that same client in the same matter or any other matter which relates to the original matter. Obviously, the question is the possible breach of confidentiality. That practitioner will, when he's acting against his former client, have knowledge that he acquired while he was acting for that client. But this does not extend beyond the same or related matters. So just because you've acted for a client doesn't mean to say there is a permanent bar against your acting against that client in other unrelated matters. And one point I should emphasize that we have changed broadly across this mandatory code. This code is directed entirely at, or almost entirely at advocates in their individual capacities. So we've used the word practitioner, and the practitioner means the actual lawyer concerned. It doesn't apply to the firm unless we say so in the rules. We say so in this code once or twice. Some of the rules do extend, but we say so explicitly. Otherwise, these are individual responsibilities assumed by each practitioner. Moving on to general duties, we have no new provisions under this section. All the provisions here are from the old or the existing code. Some of the wording has been amended for clarity and for stylistic reasons. Let me move on now to Part F, sanctions for breach of the code. Rule 25 has been amended slightly. Rule 25 of the new Part F is equivalent to Rule 26 of the existing mandatory code. Now, under the existing Rule 26, what that says is if there is a complaint made against the practitioner, and the complaint involves the registrar or the Chief Justice to any significant degree, the Chief Justice shall nominate the Deputy Registrar or any Justice of the Court to act instead of the registrar, and any Justice of the Court to act instead of the Chief Justice. In Rule 25, we've changed that slightly so that in the circumstances I've described, the Chief Justice may nominate any other officer of the court to discharge any of the registrar's duties under Part F. So it's not confined just to the another judge or the deputy registrar. Moving on, we have got two other rules that are worthy of mention. They are related to this. 26, I think, is either entirely new or significantly different from the existing code. Rule 26 says, a complaint under this part may be made by the court itself. Where the court is the complainant, the complaint shall be made by the court acting through the registrar or any other officer of the court as the Chief Justice may appoint for that purpose. So this is to take care of cases where the complaint is not by another practitioner or even a lay client. It is where the court, typically in observing the behavior of practitioners either in court or through the correspondence leading to the hearing, decides that some disciplinary action needs to be taken against a practitioner, and Rule 26 just spells out the mechanism by which that is to be done. Rule 27, which is new again, we have a time bar. No complaint received by the registrar more than 12 months after the facts complained of shall be accepted, unless the registrar is satisfied that the complainant suffered from an impediment that prevented him or them making the complaint within that time. Where the registrar is satisfied that the complainant suffered from an impediment, the complaint will not be accepted if received more than 12 months after the removal of such impediment. So that gives some protection to practitioners against what you might describe as stale complaints. Then we've added a new provision, still under Part F, which is now Rule 31, Sub-Rule 4. And this describes what happens when there is an appeal process. Now, first of all, I have to tell you about Rule 32 before coming back to Rule 31.4. The new Rule 32 says that a decision may be reviewed or at its discretion a complaint reheard by the Court of Appeal on the application of the practitioner or the complainant. So the existing procedure envisages that the registrar or some other officer of the court investigates the complaint, and if the practitioner complained against requests, the registrar will be assisted by 2 assessors who will typically be senior lawyers from this jurisdiction. From the decision of that panel, there will be a right of review by the Chief Justice. And so on top of that, we are now providing an additional layer of second review by the Court of Appeal. Because we've introduced that layer of second appeal, 31.4 now reads, save where the Court of Appeal orders otherwise, the court may stay the implementation of any sanction and or direct that its decision shall be kept confidential for a period not exceeding 60 clear days from the date it was issued. So in other words, once a decision on the complaint has been made and issued, and the practitioner indicates that he or she wants to take the matter further, he's not happy with the outcome, or even the complainant, I suppose, then the decision may be ordered to be kept confidential if the court so orders, subject always to the right of the Court of Appeal to determine otherwise. Now let me move on to Part G, which is something completely new. What we realized when we reviewed the mandatory code in the light of the Code of Best Legal Professional Practice was that the sanctions that are contained in the present mandatory code are linked to breaches of the ethical rules which are set out in the code itself and no others. Now, what is missing from this whole regimen is what happens if a practitioner acts in such a way that in any other mature legal society, he would be subject to sanctions from his or her bar association. How do we enforce some disciplinary action against that practitioner when he or she has not simply committed some particular breach of a particular ethical rule, but has done something, for want of a better term, considered to be heinous, sufficiently serious to warrant some action by the profession as a whole to discipline or maybe even remove this person from the right to practice. So that is set out in Part G. And Part G contains one rule, but many sub-rules. And that rule is Rule 33. And it lists out a series of circumstances which will then attract a possible sanction from the court. I'll list out for you now these circumstances. First, if a practitioner has been sentenced to a term of imprisonment in respect of any civil or criminal proceedings in Dubai or elsewhere. Second, if a practitioner has been convicted of an offense involving dishonesty or fraud in Dubai or elsewhere, even if he is not sentenced to a term of imprisonment. Third, if a practitioner has been convicted of an offense in relation to his conduct in his practice of law in Dubai or elsewhere. Fourth, if, as a result of a bankruptcy order made against him, the practitioner is prohibited by the relevant bankruptcy law from having charge of clients' money. Now, this is a rule which is peculiar to the nature of the way in which practice is conducted in DIFC. Because we don't have a separate bar, all advocates also have the right to act as solicitors in a contentious matter. So they would theoretically, and sometimes in practice, have control over the money in their client's account. So if a practitioner becomes bankrupt, which could be for entirely financial reasons without any moral turpitude, nevertheless, for the protection of clients, it's necessary that these people are not permitted to practice in any way that gives them control over clients' monies. The sixth condition is if the practitioner has been found guilty by any court or tribunal outside the DIFC having jurisdiction over his conduct as a practicing lawyer, whether in Dubai or elsewhere, of a violation of a code of professional ethics applicable to him. Basically meaning that if a practitioner in the DIFC gets into trouble with his home bar, then we will take cognizance of that. The next circumstance has nothing to do with fault. But if a practitioner is incapacitated by illness or accident, or by the practitioner's physical or mental condition, to such an extent as to be unable to attend to his practice. I don't think I need to elaborate on this. We need to protect the public from people who are simply incapable of doing their job to the detriment of their clients. The next condition is if a practitioner is incapable of conducting cases in court as an advocate, either because of difficulties with the English language or by reason of a lack of appropriate litigation experience. Now, all of you know now that our requirements are that there must be a minimal standard of proficiency in English to be able to run the case in this court, as well as having experience as an advocate. If it turns out that despite their adherence to these two requirements on paper, in practice it doesn't work out, this court reserves the right to reconsider their standing before this court. The last condition I added at the last moment. If a practitioner has stolen or otherwise improperly dealt with clients' monies. The reason why I added this, even though we've had all of these provisions about offenses involving dishonesty, all of those first three conditions require a conviction. So if you have a situation where a lawyer misappropriates money and then goes on the run, you're never going to get a conviction, but nevertheless, he needs to be struck off. So that provision covers that circumstance. Now, if any of these conditions are met, then these are the powers of the court. Now, this order can only be made by the CFI. And it will be on the application of an officer of the registry. The first power that we have is to suspend the practitioner from exercising his rights as a registered practitioner for an appropriate period. Second, alternative sanction, impose conditions with which the practitioner must comply on a continuing basis in order to remain enrolled on the register of practitioners. And that's a wide discretion. And experience from other countries will teach us what kind of conditions are appropriate. For example, in the case of the bankrupt lawyer, so long as he doesn't have power to sign checks on client's account, that could be a condition for him continuing to be able to practice. The third possible sanction is to terminate the right of the practitioner to remain enrolled on the register of practitioners. So basically, it is a striking off. And finally, the appellate procedure. If the CFI makes such an order, it can be appealed against by way of review or actually reheard by the Court of Appeal on the application of the practitioner. So it's a right of appeal or review only by the practitioner. And again, we have a saving rule that says unless the Court of Appeal orders otherwise, the CFI may stay the implementation of its order and direct that its order to be kept confidential for a period not exceeding 60 clear days from the date it was issued. I've now explained to you all the major changes that are being made in the new mandatory code. I'm now going to call on Philip Punwa, and I'll explain why Philip has been chosen for this particular task. We had an advisory committee, and Philip was very active on that advisory committee. And when he looked at the mass of new rules that we were going to migrate into the code from the Code of Best Legal Professional Practice, he was the one who said, look, we shouldn't try and confuse the profession and make it clear where the substantive changes to the predicate rules are. And so all of the additional rules that we thought fit to introduce into the Code of Best Legal Professional Practice have been put into the Supplementary Code of Conduct. And Philip has been largely responsible for drafting this supplementary code. So I will now hand over to Philip.
Good morning, everyone. Thank you very much indeed, Chief Justice. The Code of Conduct subcommittee of the Court Users Committee was convened quite a few years back, probably in about 2007 or thereabouts. And as the Chief Justice has already pointed out, that subcommittee ultimately was responsible for the introduction of the original Code of Conduct. The original subcommittee was subsequently reconvened when, as the Chief Justice indicated, it became clear that it was time to update the Code of Conduct. And when I indicated that as a practitioner, I hoped we could do it in such a way as to make the changes we were introducing as accessible to practitioners as possible. I hoped we wouldn't have to reinvent the wheel. And that is indeed why we have the revised mandatory Code of Conduct and alongside it what we call the Supplementary Code of Conduct Practice Direction Number 1. In future, there may well be further Supplementary Code of Conduct Practice Directions. Practice Direction Number 2, for example, might deal with a specific point, whereas Supplementary Practice Direction Number 3 might in fact amount to a reissue of all pre-existing supplements to the Code of Conduct. For the moment, though, what you will find when you look at the Supplementary Code of Conduct Practice Direction that you have before us, Supplementary Code of Conduct Practice Direction Number 1, is that it is set out in such a way as to ensure that it follows the mandatory code. So, for example, on page 1, you have Part B, the heading Part B, and that indicates to you that you're now going to be taken to additional provisions to Part B of the mandatory code. Part B, as you know, deals with duties owed to the court. So, for example, if you look at the first entry under Part B, you see in the left-hand margin it says SPD, that means Supplementary Practice Direction B4. And so you would be probably well advised to remind yourself what B4 in the mandatory code said before you then turned your attention to the supplementary provisions. So if we look at Part B4 of the mandatory code, we'll see that it says practitioners shall never knowingly or recklessly make any incorrect or misleading statement of fact or law to the court, and shall correct any material incorrect or misleading statement of fact or law at the earliest opportunity. SPD B4 Roman 1 provides that a practitioner who knows of facts which would assist his opponent is not under any duty to voluntarily inform his opponent or the court of this to the detriment of his own client. So the intention there is to make sure that practitioners recognize that whilst they're not under an obligation, that they are under an obligation not to mislead the court, they would not be in contravention of that provision of the mandatory code were they simply not to bring facts that they were aware of to the attention of their opponent, to the detriment of their client. So we hope that the supplementary provisions will help practitioners by identifying conduct which would amount to a breach of a term of the mandatory code, and we also hope that the supplementary provisions will make it clear when certain conduct would not amount to a breach of a provision of the mandatory code. Now, as a practitioner, what I find those provisions of the supplementary Code of Conduct Practice Direction that I find most helpful and that I think will be most helpful to most practitioners are those that deal with duties owed to clients. So, for example, if you look at page 2 of the Supplementary Code of Conduct Practice Direction number 1, you will see Part C, Duties Owed to Clients, exactly the same heading as we have in the Mandatory Code. And then you'll see that SPD C7.1 provides that it is an implied term of each practitioner's retainer that he is free to present his client's case at the trial or hearing in such a way as he considers appropriate. If the client's express instructions do not permit a practitioner to present the case in what the practitioner considers to be the most appropriate manner, he may withdraw from the case after seeking the approval of the court. So those sorts of provisions are intended to ensure that the practitioner knows exactly what their rights in effect are in that particular matter. C7 of the code itself, you may well already be familiar with, that states, practitioners shall fearlessly advance, defend, and protect the interests of their client before the court without regard to any consequences to themselves or any other person. So whilst you are under an obligation to fearlessly advance, defend, and protect the interests of your client, that's not to say that you don't have a right to only act before the court in a manner that you personally believe is appropriate. And obviously, we all know that there are times when we do have clients who put us as advocates under a lot of pressure to present a case in a certain way, and this provision in the supplement is intended to enable practitioners to fortify themselves in those circumstances and equip them with the material to kick back at clients in circumstances where they are being put under inappropriate pressure to present a case in a certain manner. Looking at the supplementary code again, and in particular Part C, staying on page 2, we'll see that SPD C7.2, the Roman 2 indicates that this is the second provision dealing with a particular paragraph in the code. We see that it says that in general there is no duty upon a practitioner to inquire in every case where he is instructed as to whether the client is telling the truth. However, where the client's instructions are such, whether because of their inherent implausibility or because of other information coming to the practitioner's knowledge, where the client's instructions are such as should put a practitioner on inquiry, the practitioner must, where practicable, check the truth of what the client tells him to the extent that such statements will be relied upon before the court or in pleadings or in affidavits. So SPD C7 2 makes it clear, as it says, that you're not under an obligation to inquire into whether the client is telling the truth, but you can't ignore circumstances which suggest that perhaps the client might not be telling the truth. And then we find SPD C7 Roman 3, that's the last provision in the supplementary Code of Conduct Practice Direction that addresses C7 of the mandatory code. We find it says that if either before or during the course of proceedings the client makes statements to the practitioner representing him which are inconsistent, this is not of itself a ground for the practitioner to refuse to act further on behalf of the client. Only where it is clear that the client is attempting to put forward false evidence to the court should the practitioner cease to act. In other circumstances, it would be for the court and not the practitioner to assess the veracity of the client's statement. So again, provisions which are intended to support the practitioner enable them to be clear in their mind what conduct will and will not necessarily put them in breach of the mandatory provisions of the Code of Conduct. Again, as a practitioner, I feel that the supplementary code provisions to E17 of the mandatory code are particularly helpful to practitioners. And if you look at page 3 of the supplementary Code of Conduct Practice Direction, you will find again Part E, General Duties, exactly the same heading as we have in the mandatory code. I'll ignore the first two, that's SPD E17 Roman 1 and 2, although they're important, and go straight to SPD E17 Roman 3. These provisions, the following provisions, help practitioners better understand their relationship with witnesses, prospective witnesses, actual witnesses, their opponent's witnesses. And so at SPD E17 Roman 3, we see that it advises the practitioner that a practitioner must not make or offer to make payment to a witness or payments to a witness which are contingent upon the nature of the evidence given or upon the outcome of the case. However, A, payment of reasonable expenses and reasonable compensation for loss of time attending court may be paid to witnesses. In the case of an expert witness, there is an implied obligation to pay a reasonable fee. So that clarifies your position when it comes to offers of payment to your client's witnesses. And then going over the page at B, a practitioner on his client's instructions may insert advertisements for witnesses to come forward to testify as to a particular occurrence. Again, a very useful provision that makes it clear just what conduct is permitted vis-à-vis the solicitation of witness evidence. You'll think that many of these provisions are self-evident, but of course we do need to remind ourselves that, as we've said in the past, I don't know if we still say it, but it is true, I believe, this is an international court, and everyone in this room who is authorized to practice recognizes that it is important that all practitioners, no matter where they're trained, no matter which jurisdiction they otherwise practice in, are confident that they know the rules of conduct by which they and their opponents have to comply. Looking at SPD E17 Roman 4, you'll see that it says a practitioner shall not interview or discuss with a witness whom the practitioner has called his evidence or the evidence of the other witness while such witness is under cross-examination. As an English lawyer, that's a provision that we're very familiar with, but it needs to be spelled out in a court like this. And it goes on, importantly, this shall not prevent the practitioner from communicating with his client or principal client representative while the latter is giving evidence for any purpose necessary for the proper management of the matter. So that ensures that you can be confident that if the witness that you've called is your principal client, the fact that they are giving evidence won't prevent you from having some communication with them, so long as that communication does not concern the evidence they're giving, but concerns the future conduct of the proceeding before the court. So I personally, as a practitioner, believe that SPD E17 is very helpful to practitioners. The supplements to E17 provide other important glosses, for want of a better word, all of which are binding, of course. So, for example, at SPD E17 Roman 10, towards the bottom of page 4 of the supplementary code, we see that a practitioner must comply with any order of the court requiring him to do or refrain from doing something. Equally, a practitioner is bound to honour his undertaking or undertakings to the court. And of course, there will be circumstances in which a practitioner appearing before the court will be asked by the judge to give a personal undertaking of one sort or another. The giving of undertakings may not be something which practitioners from all jurisdictions are familiar with, and the code makes it clear that it is not a matter of any insignificance, the giving of an undertaking. And then following on, SPD E17 Roman 11, I'm going to take you over the page to 11C. So that reads, when conducting proceedings in the court, a practitioner shall bring any procedural irregularity to the attention of the court during the hearing and not reserve such matter to be raised on appeal or in setting aside proceedings. Again, something that probably we're all familiar with if we come from England and Wales, but again, it needs to be made clear that you can't store up an irregularity for the purposes of an appeal, and the fact that it's set out there obviously will assist you if you should be unfortunate enough to have a client who is hopeful that that's exactly what can be done. The parts of the supplementary Code of Conduct, Practice Direction number 1, that augment parts F and G of the code are there primarily because they address the ability of a complainant or a practitioner under Part F to appeal to the Court of Appeal. So the supplementary provisions there primarily deal with the procedure of an appeal. That procedure is entirely new for the purposes of the Code of Conduct. So, for example, if we do look at those provisions that deal with Part F, you'll see that, in fact, they all, without exception, on page 6, deal with F32 of the Code of Conduct. So if we look at F32 of the Code of Conduct, we will see that it very shortly provides that a decision may be reviewed or at its discretion a complaint reheard by the Court of Appeal on the application of the practitioner or the complainant. We didn't want to overload the mandatory code with procedure. That's not helpful to a practitioner who's new to the jurisdiction and wants to be confident that quite quickly they can get to grips with the fundamentals of the Code of Conduct. Hence, we have the provisions that you see here in the supplement. And so, for example, if we look at the supplement, This is page 6 towards the top, under Part F. We have SPD F32 Roman 1, an application to the Court of Appeal shall be made using the procedure set out in Part 8 of the rules, the RDC. And then importantly, it goes on to say, save where the application to the Court of Appeal is made by the complainant, no permission to the Court of Appeal shall be required. So a practitioner has an automatic right of appeal against a sanction, for example, imposed against them following the Part F procedure. And looking at page 6 of the supplement again, we'll see that at SPD F32 Roman 4 in the middle of the page, it says where permission is required to appeal, an application for permission shall be included in the Part 8 claim form. An important provision is towards the bottom, SPD F32 Roman 7, any decision appealed against, together with any application to the Court of Appeal, shall be kept confidential until the appeal is determined. And then following that, Roman 8, an application to the Court of Appeal shall not operate as a stay of any sanction. So obviously a separate application will need to be made by the practitioner if they wish for there to be a stay of the sanction. And moving over to Part G, the supplementary provisions dealing with Part G, Part G again provides for appeal. Part G 33(1), if we remind ourselves, 33(1) provides provides for the making of a referral by an officer of the registry. And again, if we look at the supplement at the top of page 7, we see Roman 1, it's provided that the court has to follow the Part 8 procedure. And if one looks towards the middle of the page, you'll see that at Roman 2, G33(2), Roman 2, there's a time limit for any application to be made to the Court of Appeal, and that's 30 days. And then there's loose wording below that at G33(2), Roman 3, which provides essentially for the making of directions as to how the matter is to thereafter proceed by the court. So within 14 days of the filing of an appellant's notice, a judge of the court shall issue directions for the management and determination of the application, including any directions for the filing of a respondent's notice. Obviously, we didn't want to overload the supplement with procedure, and so, as I said, very loose language there intended to ensure that thereafter the court can give such directions for the management of an appeal under Part G as are appropriate. So I've touched on a few provisions only that I as a practitioner feel are there to assist practitioners, and it may be that the Chief Justice would like to identify any provisions that he feels are particularly useful for clients or for the court itself. But otherwise, if that's not the case, then I think that we are here to answer questions. Constructive criticism is always welcome. I'm sure this code of conduct will develop over time. We do hope that with the supplements, the code of conduct can be organic. And so as issues arise in the course of proceedings that cause concern to practitioners or the court or to clients, the code can be amended relatively speedily to reflect what's needed from practitioners and others to deal with that issue. Thank you very much indeed.
Yes, you may ask a question.
Suppose some claims somebody will misuse this provision against a lawyer. For example, since we are case to pay, maybe the client will get against and maybe they get tax for misusing. So what's the protection for these practitioners?
Were you saying that you think that complaints about practitioners might be brought by clients for improper reasons? Was that the point you were making? I didn't quite know.
The misuse of solutions by the clients. If they make a false complaint against a lawyer, and maybe some, for example, have a case fee, maybe lawyers to the fees. After that, the claims to against the lawyer, maybe some allegations.
The mandatory code has always provided, as it does today at paragraph 28, if you've got it there in front of you, it's on page 4 of the mandatory code. Paragraph 28 starts off by saying, unless the registrar decides on reasonable grounds that the complaint is frivolous or vexatious, he shall forward a copy of the complaint to the practitioner, etc. So we were mindful that it's not impossible that the registrar might receive what on its face is clearly a frivolous complaint, and therefore we did think it appropriate to make it clear that the registrar could essentially refuse to accept a complaint of that nature.
The question that I have relates to the mandatory code, Part G, matters affecting registration. And at 33(1)H, where a practitioner has stolen or otherwise improperly dealt with the client's money, and Chief Justice, you alerted to the circumstance of someone who didn't stay for a trial of that matter. My question relates to the standard of proof the judge has to be satisfied of that individual has stolen or otherwise improperly dealt with client's money. Is it the civil or criminal standard?
That's the general rule of evidence, and I think we are likely, there are no definitive manuals on the law of evidence in DIFC, but I think in common law countries we typically say that if the proceeding is a civil proceeding and an issue of whether or not a criminal offense is being committed, you simply need to be a little bit more satisfied of the guilt of that offense than you would be in an ordinary civil court when you were deciding a plain issue of fact. Where that plain issue of fact takes on the color of a fraudulent or criminal offense, then without saying, well, definitely I think very few jurisdictions say you have to prove it to the same level as the criminal standard. I think Malaysia still does, but most other common law countries say no, it's got to be higher than the balance of probabilities, but not as high as beyond a reasonable doubt. I think that's the standard we're likely to adopt, subject to my colleagues' views.
Thank you.
Just a more technical point, I didn't quite understand. Any procedural irregularity shall be brought to the attention of the court. There's two issues there. Otherwise it was said, in case the client believes this can be done. My understanding is that this is a disciplinary code, so I could be disciplined if I did it, but that doesn't stop the client from raising it in appeal, even if they didn't earlier on. And secondly, it says, shall bring to the attention. What happens if I don't realise until later?
All of these offences presume a mens rea on the part of the lawyer concerned. So if there is a point in reviewing the whole transcript, it dawns on the lawyer that actually there was a procedural irregularity, which he was not aware of at the time. He's certainly entitled to prove it. But the court is entitled also, in hearing the appeal, to ask, when did you first realize? And why didn't you tell the judge at the time? So, yes, the client's legal rights will be preserved if there is an operative irregularity which could affect the outcome of the decision of the court. The court will judge it on that basis. But there's a separate exercise as to whether or not the way in which it was brought up was complied with the court's expectation of the way in which the counsel should behave. That could result in some kind of cost implications in the ultimate order that might be made. For example, the court could say, yes, I'm going to allow your appeal because of this error, but since that error, we think you knew about it or should have known about it, and if you had known about it, the whole thing would have been dealt with below, then we're not going to give you the cost of this appeal. You know, that kind of outcome could be possible.
If the dispute, if the conduct took place before the new code came in, but the complaint was filed after the new code came in, do we apply the old code?
Chief Justice.
To the extent that new offences are created under the mandatory code, I think we would probably only apply those new provisions after today. The supplementary code is actually meant to clarify. So it was inherent in the old rules that the interpretation given or the explanations given in the supplementary code might help us to understand what the true intention of the promulgator was at the time. I think we could look at it and decide. I mean, some of them are actually not only explanations, but adding additional detailed requirements. But we'll take that as it comes. But generally speaking, yes, I mean, to the extent that these things are treated as quasi-criminal, notwithstanding that they are absolutely acknowledge a higher obligation to respect the rights of practitioners and not to penalize people for things they didn't know were illegal at the time. Are there any other questions? Otherwise, I'm just going to end up with the pitch. Let me again remind people of why we brought in the Code of Best Legal Professional Practice in the first place. Because people would ask, it's all very well having a code, but if it's non-binding, what effect does that have? As we said, first of all, we try and establish what would be considered best practices in the legal profession in the DIFC. In the second place, we hope that despite the absence of the Bar Association in Dubai and DIFC, the lawyers of the DIFC Bar will feel some sense of cohesion and camaraderie to want to promote the image of Dubai and DIFC in particular as a legal hub. You can't have a legal hub if your practitioners do not adhere to international standards of conduct and ethics. And what I would like to see is that all law firms here, after having studied the code, the mandatory code of course binds regardless, but it is the non-binding part of the Code of Best Legal Professional Practice that I want the law firms to look at, particularly as it relates to people who are not going to come to court, the transactional lawyers. But that's all part of creating the image of DIFC as a legal hub, international legal hub. And I would like to see the law firms branding themselves as adherents to the DIFC Court's Code of Best Legal Professional Practice. Now, to me, that can be regarded as a marketing point. You're telling your clients, we will be bound by the best practices of this jurisdiction. I think it's something worth doing, and whether or not you brand yourselves, you should carry out your practice in a way that conforms with the code.
Chief Justice, I wonder if I can have an opportunity to plug the DIFC advocacy training courses that we're running. Mark Veer got his plug regarding the gala dinner. You just had yours, so I have entitlement. As many of you will know, because I recognise a number of attendees from our previous advocacy training courses, we have been running DIFC advocacy training courses for the last year or thereabouts. And in November, we're hoping to run our third advocacy training course, or the sixth, depending how you look at it. The courses we run at the moment comprise a one-day introductory course. It's an introduction to the common law trial process, and that takes place normally in the court and doesn't require any preparation whatsoever. And that's intended primarily for civil practitioners, civil law practitioners, and common law practitioners who want to remind themselves what it's all about in the common law world, the trial, and advocacy generally. Then we run a two-day course which follows the Hemphill method of training, and there is pre-reading for that, and that involves groups of 6 working with 1 or 2 trainers, video performances of examinations in chief and cross-examinations and re-examinations, and video reviews. At the moment, we describe our courses as level 1 courses, and there's an introductory course, I suppose, and then the 2-day course is a level 1 course because it's pretty general, great fun. But we are in the future planning to introduce level 2 and level 3 courses, and in the spring of next year we hope to run our first level 2 course, which will be again a 2-day course over a Saturday and Sunday, but focusing on applications advocacy, and then thereafter further courses of progressing complexity. So do please register your interest in advocacy training with the DIFC registry, and keep an eye on the website, because obviously we feel that the advocacy training is as important a part of the work of the DIFC as the promulgation of the code of conduct. Thank you.
Thank you very much, Philip. I do want to publicly acknowledge the work of Philip and his colleagues, the various committees of this court and in our academy, particularly now for the training, for the overall improvement of the standards of the legal profession in this jurisdiction. So thank you very much for your attendance, and good morning to you all.